Good day, everybody. This is Steve Garai, real estate broker for KW Urbain. I have the distinct pleasure of having Jaimie Benizri with me today. He is the founder, president, and attorney at Legal Logik. Welcome to our show, Jaimie.
Thanks for having me. It's good to be here.
It's a pleasure to have you. Jaimie, we've got two questions for you today.
Go ahead.
The first one is, during our last information session, you mentioned that frequently in your business, you see the two parties to a real estate transaction, the buyer and the seller, sometimes at odds with each other and the relationship being strained, in particular when the possession date does not match the signing of the act of sale of the notaries. In other words, the possession date is later after the act of sale has been signed. I was wondering whether you would be able to summarize for us what you mentioned to us, because I think that's really great information for people to know, how they can actually reduce the possibility of conflict during that time.
I think it's an excellent question, and I think that it's often overlooked by a lot of real estate brokers. What's important to note and what's important to provide under any circumstance are the consequences of a seller that overstays his or her welcome. Now, in a little known clause that's often unbeknownst and often overlooked when filling out a promise to purchase, section 11, which deals with occupation in general, there is a clause or there's an opportunity for whoever fills out that form to provide for a certain penalty or to provide for a certain amount in the event that the seller fails to leave after the time that he's expected to leave. Mm-hmm. In the case that you're talking about, when the transaction and when the transaction at the notary and the possession of the buyer are not at the exact same moment, meaning that the occupation is at some point after the signing at the notary, it is common that the parties would agree on a certain amount, be it $500 per week, $50 per day, whatever the parties agree to. Mm-hmm. That's the section, that's the clause that's going to provide for that exact amount. Let's not leave it up to interpretation when there's a problem. Let's provide for it before. In that case, if the seller overstays his welcome, we're going to apply that clause. And we're going to be able to use that clause to base our damages and to really make the foundation of a claim going forward. So the equation really is section 11, particularly 11.2, plus any other damages that the buyer will have incurred on account of the seller refusing or having a delayed departure, mm-hmm. be it through storage fees, hotel fees, or otherwise. So that's the application of that clause, and all real estate brokers are cautioned to use it.
Indeed. So some kind of an indemnity to clarify the matter should such an event occur.
The word is indemnity. We can call it a penalty. What it is basically is a dissuasive, is an opportunity to provide some sort of a dissuasive measure for the seller, just to maintain occupancy for as long as he would like.
Makes sense. Thanks, Jaimie. And question number two, and I found this aspect particularly interesting because I come from a financial services background. You mentioned that a great deal of your business deals with estate matters. I was wondering whether you could give us a little more information about what you see in your practice, the intersection of real estate and estate planning. Perhaps it is. Maybe you can share some of that information.
It's a passion. It's what I practice on a regular basis. And although the question is broad, and I'd like to speak about it for a long time, I'll limit myself for the purposes of this interview to talk about the importance of an heir or someone who is responsible for overseeing someone's assets, whether they are incapacitated legally or whether they are deceased. There's often real estate involved. Now, the most important things to provide for as a liquidator of someone's estate is their real estate, and to make sure that everything you do specifically with respect to a real estate transaction. So you want to make sure that sale is being performed, without legal warranty, because oftentimes we do not know of any hidden defects or any potential latent defects in our relative's home. So you want to make sure that when you do certain things, specifically real estate related, there are certain exclusions, and this is something that your broker will be able to guide you in.
Makes sense. Jaimie, thank you very much for this.
It's a pleasure to be here, sir. Anytime.
And we will have you back, absolutely. And I'd like to also thank you, dear viewer, for having attended. If you like this information session, please don't hesitate. Give us a thumbs up. Perhaps in the notes below, give us some feedback and what subjects you'd like us to treat in an upcoming episode. Thank you and have a wonderful day.